And you were texting this to your high school friends, again, 16 hours into this investigation, right?
Correct.
And you knew at that time, Trooper Proctor, that this was not going to implicate in any way, shape, form, or fashion another cop, correct?
Correct.
In this text exchange, let's turn to 2532, actually. You have that in front of you?
I do.
In this text exchange at 10:56 p.m., your buddy Bird writes, "I'm sure the owners of the house will receive some shit," correct?
Correct.
How did you take that to mean? Did you take that to mean that he could get in trouble?
Yeah, I'm not sure exactly what my friend was getting at.
Well, you had some idea.
Yeah,
maybe the owners of the house isn't going to get any shit for this, right?
That's how I interpreted it.
Yeah, you interpreted it like he's not going to get in any trouble. He's not going to be a suspect, correct?
Correct.
And he's not going to be implicated in any way. Is that right?
Correct.
And your answer was one word, correct?
Yes.
What was that word?
Nope.
And then you followed that up with an explanation as to why you said no, didn't you?
That wasn't the explanation why I said nope. I simply said homeowner's a Boston cop too, meaning Mr. O'Keefe was a Boston cop. The homeowner is a Boston cop as well.
The question that preceded your answer, nope, the homeowner's a Boston cop too, was the homeowner's going to get some shit for this, correct?
That's not what I meant with that text.
That's what you wrote.
Not what I meant, sir.
All right, let's take it in order. Question. Oh, goodness, the homeowner's going to get some shit for this. Answer, nope. Next text, he's a Boston cop too. That doesn't sound like an explanation for your nope.
No, that's just saying he's a Boston cop as well, Mr. O'Keefe.
And that's why he's not going to get any shit, correct, Trooper Proctor?
Well, he's not going to receive any shit, sir, because Mr. Albert, the homeowner, had nothing to do with Mr. O'Keefe's death.
And you knew this 16 hours into your investigation.
Yes.
In a day.
Yes.
To your satisfaction.
To my satisfaction,
and you
to the members of my unit.
So let him finish. We didn't get finish your answer.
To my satisfaction, and to all the members of my unit who investigated that day.
Objection. Also speculation.
So I'm going to let it stand. Trooper Proctor, you have to keep your voice up, okay? Jurors need to hear you way back there.
Yes, ma'am.
The fact of the matter is, you hadn't been to the crime scene by the time you wrote this text, correct?
Correct.
You hadn't been inside the home, correct?
No.
You had questioned a grand total of 3 recipient witnesses at this point, correct?
Yes.
And 2 of the 3 were named McCabe, right?
Correct.
And 1 of the 3 was named Albert, correct?
Yes.
And it's against that backdrop that you wrote, nope, the homeowner's not going to get any shit because he's a cop, right?
That's not what I meant by that.
As a matter of fact, both you and Sergeant Buchanan believed that he had suffered the injuries as a result of a physical altercation based on information you received from the paramedics initially, right?
Initially, we didn't know what we had. We knew there were some significant injuries to Mr. O'Keefe. And we're still figuring out how those injuries occurred.
Well, you just testified. Initially, we didn't know what we had.
Right.
But 16 hours after the fact, you wrote the following sentence. That's what I initially thought after talking to Canton paramedics, correct?
Correct.
So initially, you did think you knew what you had. A physical altercation leading to a death, correct?
Correct.
So when you just said, initially we didn't know what we had, that wasn't quite true. You did at least have an idea of what you thought you had, correct? Judge.
Sustained.
Then before you ever interviewed Julie, your sister informed you that Julie actually wanted to get you a gift for your participation on this case, correct?
Yes.
In tab 5, let's turn to page 2672. Trooper Proctor. With court's permission, may we publish?
Yes.
Page 2672. You see the text from you, what's up?
Yes.
And what's Courtney Proctor's response?
Nothing. I just saw Julie, and she said, when this is all over, she wants to get you a thank you gift. And I respond with, get Elizabeth one.
Hang on just a second. Let's take them one at a time. You were asked about this on direct examination by Mr. Lowell, right?
Correct.
And you looked at the jurors, paused, and said, I never asked for a gift. I never received a gift. Elizabeth never asked for a gift. She never received a gift. Remember that?
Correct.
You said you never asked for a gift, correct?
Correct.
What's your next text?
Get Elizabeth one.
Get Elizabeth one what?
Referring to a gift.
Right. So you did, in fact, ask for a gift, didn't you?
For my wife, who had been home with my children for the last 10 nights.
From Julie Albert.
Yes.
For your participation on this case.
I don't know if that's yes.
Well, Courtney Proctor answers that question by saying, because I guess her and Chris were friends and John, and she's so proud of you for leading this investigation, correct?
Correct.
Ms. McLaughlin, who's Caitlin Albert?
I went to high school with somebody named Caitlin Albert.
Is somebody named Caitlin Albert?
I went to high school with somebody named Caitlin Albert.
Did you know Caitlin Albert?
I do.
Friends with Caitlin Albert?
I would say more acquaintances, not close friends.
How do you describe acquaintance?
I would say that we have mutual friends, so we might see each other occasionally because of mutual friends, but we don't We don't have a one-on-one friendship or hang out regularly.
Who's her dad?
I don't know.
Objections.
Do you know who her family is?
Objection.
Sustained.
Maybe for
Yes.
When we last left off, I was asking you about your relationship with Caitlin Albert. Recall that?
Yes,
I want to ask you a few more questions about that. You and Caitlin Albert have known each other for how long?
since high school.
Which is, give me a span of time.
So probably about 10 years.
You have traveled with Caitlin Albert and friends. When I say traveled, I don't mean to exotic locations. I mean day trips, etc.
Yes,
You have a group of mutual friends together, correct?
we have mutual friends. Correct.
Those mutual friends have gone on day trips with you and Caitlin Albert involved
Correct.
on more than one occasion, as a matter of fact.
Correct.
On many occasions, as a matter of fact.
I don't know.
More than 5?
I don't know.
More than 10?
I don't know.
You've seen photographs of you with Caitlin Albert on some of these day trips, correct?
Yes.
You've seen at least 3 of those photographs.
Yes.
You're friends with Caitlin Albert on social media.
Yes.
Other than the 3 photographs that you've seen, we just talked about, there have been other events that you've been at with Caitlin Albert that weren't necessarily photographed, but we don't have those photographs, correct?
Probably.
You know that Caitlin Albert is the same Caitlin Albert as the daughter of Brian and Nicole Albert, as you sit here.
Yes. As I sit here today, yes.
And you know that Caitlin Albert also has siblings, Brian Albert Jr., correct?
As I sit here today, yes, I know that.
And you also know, as you sit here today, that 34 Fairview was, at the time, January 29th, 2022, the Albert home, correct?
I know that as of today.
And McCabe was back on the stand. She was with Reed the morning John O'Keefe was found dead. And new at 6, the defense peppered McCabe with questions about calls to O'Keefe that were deleted from her phone. As WBZ's Christina Rex shows us, the questioning was tense from the start.
You're spinning all of this.
Ma'am, I do a lot of things.
Yeah.
I don't spin. There's a judge here to make sure that I don't spin. I'm asking you a question. It's very direct.
That tense and at times hostile back and forth defined the 4 hours of Jen McCabe's cross-examination Tuesday. McCabe was with Karen Reed when they found John O'Keefe's body. She testified that she heard Karen say she hit him. Testimony the defense says has changed over the years. Instead, lawyer Alan Jackson painted Jen as the orchestrator of the narrative told by her family and friends.
Have you spoken to them about these events between then and now?
About this case? Is that what you're asking?
Yes, Ms. McCabe, I'm asking you about this case.
Of course I speak to them all the time about the vicious harassment we are all receiving.
Karen Reed's team accused McCabe of an off-the-books meeting with a Canton cop in the days after John's death. And the jury heard for the first time allegations that Jen deleted at least 6 calls she made to John O'Keefe between 12:29 and 12:50 that night.
I believe I used the word butt dials.
You claimed that every one of these calls was a butt dial. Is that right?
Yes.
Defense lawyers believe those deleted calls could provide reasonable doubt for the jury.
Butt dialing is becoming a thing with the Albert clan. Like, how bizarre is that?
And so you say John is in the house, his phone's missing, she's calling him to find his phone.
That's certainly a reasonable interpretation.
Jennifer McCabe was back on the stand this morning for tense questioning about Google searches that she made and what time she made them on the day Boston police officer John O'Keefe's body was found in the snow. This morning, Karen Reed's lawyers questioned McCabe about the now infamous misspelled Google search she made, "How long to die in cold." She says Reed told her to make those Google searches.
She was screaming, Google hypothermia, how long does it take to die in the cold? And I picked up my phone and I started Googling.
In court today, the defense pointed to cell phone data showing the first time McCabe made that search was at 2:27 in the morning, hours before John O'Keefe's body was discovered. Defense attorney Alan Jackson says the timing of the search exonerates Karen Reed and implicates McCabe in O'Keefe's death.
Ms. McCabe, you made that search at 2:27 a.m. because you knew that John O'Keefe was outside in your sister's lawn dying in the cold, didn't you?
Absolutely not. I did not make that search at that time. No.
Did you delete that search because you knew that you would be implicated in John O'Keefe's death if that search was found on your phone?
I did not delete that search. I never made that search at 2:23. I never would have left John O'Keefe out in the cold to die because he was my friend that I loved.
In court filings, the prosecution has said the defense is misinterpreting that cell phone data. Reed's lawyers are trying to convince the jury that McCabe is part of a scheme to frame Reed for O'Keefe's death.
The right rear taillight had large pieces missing from it.
The defense says Proctor broke the taillight after the SUV was seized as evidence and brought to the Canton Police Department. Proctor denied that.
Besides a mechanic, I never touched any part of that vehicle.
Proctor says he never made any decisions about the case on his own, and that he conducted nearly all the interviews with other officers present. He said he does know the Albert family, who owned the home where O'Keefe was found, but only through his sister and not well.
I classify it as acquaintances.
Earlier, another investigator, Sergeant Yuri Buchanan, was again grilled about video of Reed's SUV at the Canton Police Department. The video was originally shown to the jury horizontally inverted.
You believe that what the jurors are seeing right here is true and accurate surveillance footage of the Sally Port that night?
Yes, it's just mirrored.
Defense attorney Alan Jackson said about 2/3 of the mirrored video is missing, and that people in the video seem to appear out of nowhere. Buchanan explained that like this.
I can tell you that the video is triggered by motion.
So he gets hit by the car, not his torso, just the arm. The taillight cracks, and as it passes by, his arm stays with it long enough to get striations, those scratches that you see, those lacerations. I'm sorry, those abrasions that you see, right?
In a sense, yes.
And at the same time, he does a pirouette and flies 30 feet to his final play rest.
I don't know if he did a pirouette.
Well, I'm using the word pirouette. He spun around.
He started rotating counterclockwise. I don't know how far he ran counterclockwise, but he started rotate. According to that, would push him to rotate counterclockwise. Well, now he went counterclockwise all the way to his back toward the ground. It seems like a most likely possibility.
Did you account for the fact that his arm is on a hinge?
Is what? Say again?
Did you account for the fact in this scenario that you just told the jurors that his arm is on a hinge?
On a
his
hinge.
shoulder?
Okay.
Okay, so, his arm got hit. His arm just swung.
I said arm and shoulder area, so his arm could be considered part of it.
Even if his shoulder got the upper,
Okay.
pointing to his upper biceps.
Mhm.
Right? There's no injuries on his shoulder. Not a single one. Not even a bruise. Right?
Like I said, it looked like to me it was from up here. I don't know how far I can back here, but it was up here.
Well,
So
the other one that talked about his injuries on his arm.
yes.
That's limited to about mid biceps, about mid forearm, right?
Okay.
Right?
Yes.
No injuries on the shoulder, no injuries on the torso, no injuries on the ribs, no injuries on the back, right? Is that right?
Yes.
So your theory is you got hit on the arm, took the brunt of the force from the taillight on the arm, stayed with the vehicle long enough for the taillight to explode, basically, to shatter. Then these striations get on his arm, abrasions. Does a pirouette, spin, counterclockwise, and flies 30 feet in the air to his point of rest.
Yeah, have probably a little faster than that, though.
Actually said he hit his head on the curb.
I said that's one of the possibilities of when you look at the roadway, as he gets spun around counterclockwise, it's a possibility that the curb is there. Any blunt force object on the ground, as the ground is pretty blunt.
Well, except in your scenario that you just told us, you flew through the air onto the light dusting of snow, grass, and dirt.
I didn't say through the air.
Say that again?
I didn't say he got thrown through the air.
Okay, I'll use your word. Yeah, projected.
Projected doesn't mean it's not incorporating just the throw. Project just means you get pushed forward. There's two parts of that. There's the air, then there's the ground.
And you agree that those injuries don't just manifest out of nowhere, right?
Absolutely.
They have to originate from something.
Yes.
Would you agree that his injuries to his face are consistent with having been punched?
That is a possibility.
You can take that down, Mr. Bates. Thank you. Your internal examination notes also cite a tongue laceration on the right front of the victim's tongue. Do you recall that?
Yes.
And you'd agree that tongue laceration can be also caused by blunt force trauma.
Correct.
And that could also include something like a punch to the victim's face or jaw.
That's a possibility.
In addition to the facial injuries, you described that Mr. O'Keefe had a significant laceration on the back of his head.
He had one laceration to the back of his head. Correct.
I believe we saw a photograph of that
Yes.
a little bit earlier. You testified that the skin around the laceration on the back of his head was also scratched. Do you recall
Yes,
that?
I do.
But you did not testify as to how you opined that might have happened.
No.
Would you agree that someone could certainly get scratched on the back of their head if they were, for instance, dragged on the ground?
It's possible.
And you'd agree that Mr. O'Keefe's head injury came from some sort of blow to the back of the head, whether it be an object or the ground. Is that right?
Yes.
Objection.
And that injury could be the result of falling backward from a standing position onto concrete.
It's possible.
It could also be the result of being struck with a large object such as a baseball bat or a barbell.
It's possible.
In other words, it was an irregular laceration that resulted from some blunt force trauma.
Correct.
I'd like to sort of circle back to those injuries to Mr. O'Keefe's arm. You testified that there were, again, no fractures, no broken bones, no significant contusions.
Correct.
But you did describe the wounds to Mr. O'Keefe's arm as having discrete linear abrasions, which were caused by some sort of blunt object, correct?
Yes.
And you'd agree that, for example, road rash does not result in this type of discrete linear wounds.
It could, but not exactly like this.
Well, typically road rash covers sort of a large area of the skin. It would be a large abrasion. I mean, you've seen numerous cases of road rash in your
Yes.
career. And it doesn't look like that.
Correct.
Blunt force trauma can include injuries from various objects, as you testified, including an animal claw, correct?
Correct.
As you testified earlier, you've indicated that based on the facts that were presented to you, you don't know what caused those significant scratches on Mr. O'Keefe's right arm.
I do not.
ask you very quickly, have you seen this before?
Yes.
Is this one of a number of photographs that you reviewed in furtherance of your evaluation of this case?
Yes, it is.
I'd like to just focus your attention on this for just a quick second and ask you, does this accurately reflect the wounds or injuries that you saw on John O'Keefe's right arm in coming to your opinions and conclusions?
Yes, it reflects the injuries that I saw in photographs.
All right. Now, based on your review of all of the data that you've talked about, all of the information that you were given and reviewed, what is your opinion or conclusion about how these injuries were sustained?
I believe that these injuries were sustained by an animal, possibly a large dog, because of the pattern of the injuries.
Could you describe for the jurors, please, on what you based that opinion?
Yes. Well, may I use the...
Sure.
Okay, thank you. There's a number of patterns here. There, on the upper part of the arm, there's parallel lines, and those were inflicted by either teeth or claw marks. So there's a number of patterns that could be teeth or claw mark. And so this is one set right here. This is the one further down, closer to the elbow, is another set of parallel marks, again, probably most likely from teeth marks. And the reason I say that is, in addition to the parallel marks up here, down here, there's also little punctate, incomplete puncture marks here, little round marks right there that were inflicted by the actual point of the tooth.
Okay, that was my question. What relevance does that have to your determination that this was likely caused by an animal?
Yes, and I can explain in a moment the various kinds of wounds that animals can inflict. But going on with the picture first. So then down right at the elbow, there's another different series of marks that again have linear abrasions up where the pointer is, and then down below some punctate, superficial, round, small abrasions, again representing upper and lower teeth.
You've been qualified in other courts to testify as an expert in the area of accident reconstruction, is that right?
Yes, sir.
You were not hired by the defense in this case, correct?
That is correct.
At the time you did your expert review, Dr. Wolf, in your consultation, you and I had never met.
That's correct.
You did not know who I was?
I did not.
You'd never met Ms. Little?
No.
Mr. Yannetti?
No.
In fact, you'd never heard of this case.
That's correct.
You were hired by another agency not connected in any way to the defense, is that right?
Correct.
And not connected in any way to the Commonwealth, is that right?
Correct.
So your analysis and your conclusions and your opinions are completely independent of the defense and the Commonwealth in this case, is that right?
Objection.
Sustained. Mr. Jackson, you can ask it differently.
When you did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct?
Correct.
That report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right?
Correct.
The defense didn't have anything to do with that, correct?
Correct.
You never met us, didn't know who we were when you did this.
Correct.
You never met Mr. Lally, didn't know who he was when you did this.
Correct.
So your analysis, opinions, testing, and conclusions were requested by a completely separate agency.
That is correct.
All right. Goes without saying, but I'm going to ask it anyway. You haven't been paid by the defense?
You have not paid us anything, no.
And you don't work for us?
That's correct.
As a matter of fact, I've never asked you specific questions about your testing before today.
That is correct.
Your work product, the report that you provided, was provided both to the defense as well as the Commonwealth. Is that right?
That's my understanding, yes.
And you were equally available to both sides?
In terms of them reaching out?
Correct.
Yes.
And I called you ultimately after receiving your report, asked if you'd join us and testify, correct?
That is correct.
Were you and your team asked to undertake a review for purposes of accident reconstruction of the case that's now pending before the court?
Yes, sir.
Was your team asked to do this by the agency that ultimately retained you, not us?
That's correct.
Who at ARCA was assigned to the team who would ultimately undertake this job of accident reconstruction?
It was myself, Dr. Andrew Rentschler, and Scott Klein.
What was Dr. Rentschler's role in this case, as it's distinguished from your role in the case?
Certainly. So Dr. Rentschler is a biomechanical engineer, and ultimately he assessed whether or not there was a mechanism for the injuries of Mr. John O'Keefe. We worked together as a team, so we weren't isolated kind of in those areas, not speaking to each other. We certainly worked together on the analysis.
Understood. If you were to presume, for purposes of my question, that an arm was struck by a vehicle taillight traveling at 24 miles an hour or thereabouts, would you expect to see patterned abrasions with no bruising?
Objection.
Or just, what would you expect to see?
What would you expect to see?
So again, I would expect to see significant trauma to the skin, to the bone, to the tendons. I wouldn't expect to see just abrasions, pattern abrasions. I mean, abrasion by very definition means that it's trauma to the skin, which is created through rubbing or grinding or friction. So it's basically something rubbing against the skin that basically wears away that top layer of skin. It's not blunt force trauma. If you have blunt force trauma, that produces a contusion or a bruising. It's not a laceration type injury where you have a cutting injury that actually produces a cut or a significant laceration. It's really just rubbing along the skin. So that would be inconsistent. If you have an arm that's actually struck at 25 miles an hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. So if that actually caused fracturing of the taillight, then parts of that taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. I didn't see any of that. Basically, just superficial abrasions, which all appear to have a similar amount of force. There's not a difference. That's the other thing. If you had a taillight shatter and explode on an arm, you would have some areas where you would have very deep contusions or lacerations, others lighter areas. But when you look at the abrasions that were noted in this case, they all appear to be the same force, generally the same direction, and the same severity, which would be inconsistent, in my opinion, with being struck at 25 miles an hour.
Assuming that a body was struck center mass with enough force from the vehicle traveling at whatever speed to project the body off the ground, would you expect to find injuries on that body?
You would, and you would actually see that there's specific injuries because let's say you're standing forward and you get hit on the right side with a vehicle. You're going to get injuries and damage to the right side of the vehicle as that vehicle impacts you. It depends on the profile of the vehicle, how high the hood comes up, whether you're going to wrap up onto the hood, or if it's a van or the back of an SUV, it will project or push your entire body to the left. So you're going to get initial contact and injuries to the right side of your body, and then if it propels you into the air, you're going to get airborne, and then you're going to contact the ground, usually with the left side of your body. So then we're going to see a correlation of injuries to the left side of your body as it slams down onto the ground as well. And at those speeds, normally you would also see more abrasions, greater abrasions, or road rash along the entire part of the body as the body then would slide until it came to the point of rest.
Is it consistent in your view with engineering principles and physics principles that you know if an arm is hit, extended, not body, just the arm is struck, for the body then to be projected?
Objection.
I'll allow that.
It's not, no. So if we have contact, your arm's down, we have contact to the arm. I mean, first of all, it's a ball and socket joint, so the arm can move independently of the rest of the body. So with enough force, even if you're contracting your arm and trying to hold it out as tight as possible, it's going to overcome that muscular contraction and basically just move the arm. So even if you had your arm straight out, again, we said it would move because of the joint, but let's assume you had a metal pole sticking out of your arm, out of your body instead of your arm, and that metal pole gets hit. What's going to happen to your body? It's just going to spin around, right? Because it's producing a moment arm, which produces a torque on the body. So your body's going to basically spin. In order to get that body, or the complete body, over, for instance, 10, 20, 30 feet into the yard, you need a force acting at the center of mass. You need an external force pushing the body that way. And that's not going to happen if you just hit the arm. It's not enough force. It's not the right mechanism to actually cause the body to somehow move that far over.